Good afternoon. I'm Hannah Buxbaum, and I'm the Associate Dean for Academic Affairs here. And on behalf of Dean Robel, who is traveling, and the Maurer School of Law, it is a pleasure to welcome you to the third major event sponsored by the Maurer School of Law's LGBT Alumni Advisory Board. 2 years ago, we hosted the board's inaugural event, a panel discussion on marriage equality for same-sex couples. And this past spring, the board sponsored a mini symposium on same-sex marriage and the future of dogma. Today, we are delighted to welcome retired federal judge Vaughn R, who will present a talk entitled On the Bench and in the Game. Judge Walker is the former chief judge of the U.S. District Court for the Northern District of California, which in 2010 struck down California's controversial Proposition 8, a voter initiative that had banned marriage for same-sex couples. We are delighted to have the opportunity to host Judge Walker today and are grateful for the support of the event's many sponsors: the law school's LGBT Alumni Advisory Board, the College of Arts and Sciences, the Office of Affirmative Action, the University Graduate School, the IU GLBT Alumni Association, the Union Board, Out at Kelly, the Center for Law, Society, and Culture, and Outlaw, the law school's LGBT student organization. And finally, I would like to thank a founding member of our LGBT Alumni Board, Steve Sanders, who made this event happen. Now, I would like to introduce Fred Amen. You can measure the prominence of our speaker by the fact that he has two introducers. Madeleine Albright last night also only had two introducers for her lecture. Fred Amen is the Roscoe O'Byrne Professor of Law, and he will introduce our featured speaker. Welcome.
Thank you very much. It is my personal pleasure to introduce our speaker today. Vaughn Walker is a Midwesterner. He was born in Watseka, Illinois, not very far across the Indiana border. He earned a bachelor's degree with high honors from the University of Michigan, and he entered law school at the University of Chicago. That's where I met Vaughn way back then. We were both first-year law students at the University of Chicago, living on the third floor of Matthew's house, as you may recall. For some reason, the riots on and around campus, the freezing cold weather, the growing reputation of the university as a place where fun goes to die, did not quite captivate him the way it did some of us. And Judge Walker decided to leave Chicago after that first year and head to sunny California. Well, all of us that got to know him in that first year class missed him, to be sure, and we all wondered what would ever become of him. Well, it turns out a lot. Vaughn ultimately received his JD from Stanford and clerked for Federal District Court Judge Robert J. Kelleher in the Central District of California. He then began the first phase of his distinguished legal career with the firm then known as Pillsbury, Madison, and Sutro, where he litigated high-profile cases in state and federal courts involving such matters as legislative redistricting, public lands, First Amendment, and antitrust law. In 1989, he was nominated by the first President Bush to the United States District Court for the Northern District of California in San Francisco, where he served for more than 20 years, 6 of them as chief judge, before stepping down earlier this year. His decisions included matters as diverse as the constitutionality of the Foreign Intelligence Surveillance Act, the application of the Warsaw Convention to claims stemming from an airline disaster off Honolulu, reparations for prisoners of war, media access to executions by lethal injection. He also decided numerous important matters in the areas of technology, antitrust, and securities litigation. Last year, in perhaps his most high-profile case, Judge Walker ruled that Proposition 8, a California ballot initiative prohibiting same-sex marriage, violated the equal protection and due process guarantees of the United States Constitution. His 136-page decision in the case Perry versus Schwarzenegger was praised for its careful reasoning and its close reliance on the extensive factual record developed in that case. The ruling is currently before the Ninth Circuit United States Court of Appeals, and the matter may very well ultimately be decided by the Supreme Court. Since leaving the bench, Judge Walker has taught at the Stanford and the Berkeley law schools. He's delivered the commencement address at Hastings College of Law. Last month, he gave the David C. Baum Memorial Lecture on Civil Liberties and Civil Rights at the University of Illinois College of Law. On behalf of the Maurer School of Law, its LGBT Advisory Board, and the many co-sponsors Dean Bucksbaum has mentioned, it's a great pleasure and a personal pleasure for me to welcome Judge Walker to his very first visit to IU and to Bloomington. His lecture is entitled On the Bench and in the Game. When Judge Walker concludes, two faculty members who specialize in courts and public law, my colleague Charlie Jay and Judy Failer of the Department of Political Science here, will offer their comments and reactions. Steve Sanders will moderate that part of the program, and he'll also take your questions for Judge Walker. Please join me in welcoming Judge Vaughn Walker.
Well, thank you, Fred, for that very kind introduction. As Dean Amon said, this is my first visit to Bloomington and Indiana University, and I can see what I've been missing all these years. This really is a beautiful place, and you have the advantage, those of you who are studying here, of matriculating in a very, very congenial physical environment. And I gather from the brief time that I've been here, the intellectual environment is equally as stimulating and pleasurable. Now, the invitation to come and speak to you today had a number of collateral benefits. First, as I said, it was the opportunity to come to Bloomington and see Indiana University, which I had not previously seen or traveled to. Second, it afforded an opportunity to reconnect with Fred Amon, who, as he said, shared the first year of law school with me at the University of Chicago. And it gave me an opportunity to reflect upon some of the things that we have done in the years since we had that first year of law school. I followed Fred's career over the years with interest, enhanced, I must say, by my recollection of some of the misadventures in which we engaged in our younger days. In addition to being first-year law students, we shared an apartment in Washington, D.C. one summer. Fred, I think, was working for Senator Javits, and I was working for the Securities and Exchange Commission. And we had a number of good times that summer and a few mishaps, one of which occurred when we went down to Hogate's, which is down on the waterfront in Washington, to buy some live crabs to bring back to the apartment. And we brought them back. We got out a large pot of water. We put the large pot of water on the stove, and the crabs in the stove, what we had failed to do was to boil the water first. And pretty soon we had crabs all over the apartment. I've been told, I've never seen it, I've been told that Woody Allen has a similar scene in one of his movies. If true, that is a case of art imitating life. And I think that summer we went down to the Blue Note, which is a nightclub in Georgetown, and Fred sat in with Carmen McRae playing. He's a very accomplished drummer. Of course, as you know, drummers, I'm told, are people who like to hang around with musicians. But he's a fabulous musician and a great guy and has been a dear friend these many years. We also, I recall when he was clerking for Judge Tuttle on the Fifth Circuit, and Judge Tuttle came out to Los Angeles to sit by designation with the Ninth Circuit. He and I got together. I think I was probably clerking for Judge Kelleher at the time. And we went out to a club on Melrose Avenue, if I remember correctly, where some poor soul was attempting to play the piano with one hand and the organ with the other hand. And not to assist the process, but quite the contrary, we requested that he play Lady of Spain. And our guffaws got us 86th from the place. In any event, you are indeed fortunate to have such an outstanding scholar as your dean, former dean, and member of the faculty, and a great good friend of many, many years. And the third collateral benefit of being asked to come to speak to you today is the opportunity to reflect on what has been, for me, a long career as a lawyer, then a judge, and now once again as a lawyer doing private judging, dispute resolution, dispute management, that sort of thing, as well as teaching, as has been referred to. Now, I'm fully aware that this invitation is largely the product of one, and only one, of the some 8,000 cases that I handle as a federal judge. Well, nestled in that fact is an irony about which I'm going to talk to you today. It's an irony that one who's been at this profession for a long time, as I have, can appreciate. Most of you have not been at this profession for a long time. Some of you not at all. Some of you never will. So I hope that I can make the irony that I want to talk about palpable to you. And it's appropriate that we have the weather that we have at the present time. It's kind of cold and rainy. And I don't want to provide cold and rainy environment in here, but I am going to give what I think is a word of caution, a word perhaps not of warning, but a word that people who are particularly focused on a particular interest, a particular point of view, need to be aware of, particularly when they enter the legal realm. Now, the case, of course, is the Proposition 8 case that Dean Amon mentioned. I'm not going to discuss the case. I'm not going to discuss the parties positioned in the case. The case is on appeal. The decision that I made is on appeal. What I have to say about the case, I said in the decision that led to the order in that case. And that is all that I should say and all that I will say about the decision itself. What I will talk about instead, however, is some of the reaction to the case and the decision and the irony that attends these. Because I found for the plaintiffs and decided that Proposition 8, as has been noted, a state proposition, a state constitutional amendment proposition, that prohibited the state's recognition of marriage among people of the same sex. As a result of that, I have been lionized by members and voices in the gay and lesbian community. And as you know, that's a pretty robust and vocal community in my hometown of San Francisco. And San Francisco is, in any event, a pretty liberal place. San Francisco values, I trust you've heard about. So the praise that has followed my ruling has not come exclusively from gays and lesbians, nor has it been confined solely to San Francisco. I received extremely flattering comments in some of the nation's major news outlets. Commentators, editorial writers, and others have been unusually positive in their reaction to the ruling. In particular, columns by Frank Rich and Linda Greenhouse in the New York Times were particularly fulsome in their praise. I was on the cover of a magazine called This Week, depicted under a rainbow flag in a mosaic posture, leading a group of gays and lesbians over a parting sea to the promised land. In addition, there has been coverage from less well-known news and editorial organizations. Through the magic of Google Alert, I learned that I had been selected as the Gentile of the Year. When this first came to my attention, I thought, well, this was surely the Anti-Defamation League, the B'nai B'rith, and so forth that had bestowed the honor, but no. It was something called the Boggs-Donovan Group, Donathan Group, an organization that states on its website to have been started by a group of Mormons to provide a thoughtful, enjoyable, and reasonable place to post and discuss Mormon topics. The website expressly disclaims an official connection to the Church of Jesus Christ of Latter-day Saints, as if reading the website would leave any doubt in your mind on that subject. The commentary in connection with the Gentile of the Year award was a humorous criticism, of course, of the LDS Church's extensive and vigorous support of the enactment of Proposition 8. So the coverage has run the gamut of groups, organizations, and media. Now, by no means has all of it been favorable. Russ Limbaugh, in his radio program, positively seethed with outrage about the ruling in me. Tony Perkins of the Family Research Council has been extremely negative and rather personal in his observations. Someone by the name of Ed Whelan, who writes for the National Review, has filed some really quite remarkable commentary. And Edwin Meese, who was Attorney General of the United States when I was first nominated to the bench, and someone who I've long considered to be a personal friend, has written op-ed pieces in the New York Times and elsewhere that were highly critical. Well, the point of this is that the reaction since the Proposition 8 case was decided, the reaction from the left side of the political spectrum has been highly positive, while that from the right has been quite negative. What a contrast this is from the situation when I was first nominated for the bench. Then, the withering criticism came from the left, while the praise flowed from the right. I was actually first nominated by President Reagan in 1987, December of 1987. And that nomination was met with vigorous criticism, especially in my hometown, liberal San Francisco. One or both of the major newspapers carried stories that the nomination was unwise or worse. The Bar Association of San Francisco passed a resolution against the nomination. The state's senior United States Senator, Alan Cranston, and the local Congress representative, Nancy Pelosi, opposed the nomination. The criticism stemmed from two sources. One, I had successfully represented the United States Olympic Committee in litigation to enforce the committee's rights under the Amateur Sports Act of 1978 to the exclusive use of the word Olympic and associated logo and designations against a group that sought to sponsor an athletic competition they wished to call the Gay Olympic Games. And second, I was a member of an athletic club whose members at the time were exclusively male. The opposition argued that I was homophobic and sexist. There were suggestions that my representation of the USOC was a cover for my own sexuality, and I was therefore particularly duplicitous and venal. Well, although there was a hearing on the nomination by President Reagan, the Democratic majority in the Senate refused to allow the nomination to come to a vote, so the nomination died at the end of President Reagan's term in office. As noted, I was renominated by President George H.W. Bush, and shortly after he took office, and again there was opposition, and it was outspoken, and the proceedings contentious, but I was eventually confirmed and took office in February 1990. But the so-called Gay Olympics case provides the pivot point or the point of departure for what I want to talk to you about this afternoon. As I noted, that case was about the USOC's rights to the exclusive use of the term Olympic and the associated designation, the associated logo with the Olympic Games and the other designations associated with the Olympic Games. The defendant in the case was an organization and an individual. The individual was a physician. His name was Thomas Waddell. He had been a decathlon competitor in, I think it was the 72 or the 76 Olympics. An outstanding citizen, a fine gentleman, a gay man, and he had the idea that it was important, in order to put to rest notions that gays are effete and sissies and so forth, that there be an athletic competition which showed that they're just as good athletes as everybody else and just as accomplished. When he began his efforts, the use of the term Olympic came to the attention of the United States Olympic Committee, which sent a letter to him, contacting him, telling him of the provisions of the Amateur Sports Act, and requesting that he cease, and the organization that he was heading cease use of the term and the designations. He agreed to do so and signed a letter to that effect. The Olympic Committee thought that was the end of the matter. He then either consulted with or perhaps came under the influence of an attorney who had spent her professional life litigating and pursuing causes related primarily to gays and lesbians. And she convinced Dr. Waddell that the USOC was going after him and his organization because of a discriminatory motive, that it was because this was the gay Olympics as opposed to some other kind of Olympics that he and his organization were being targeted. And she persuaded him and the organization to resume the use of Olympic and these designations. And of course, the USOC became aware of this, hired the law firm that I was then practicing with to pursue the matter, and I was assigned the case, which I did pursue. We got a preliminary injunction, defended it successfully on appeal, came back to the district court, got a final judgment and attorney fees, successfully defended that on appeal. All the while, throughout the entire litigation, the tenor of the defense that was asserted was that the prosecution of these trademark rights by the USOC was essentially an act of discrimination directed to gays and lesbians. There were other arguments that were made, but that was clearly the theme that ran through the entire presentation. And that would have been the end of the case, I'm quite sure, except for one irony. Alex Kaczynski, now the chief judge of the Ninth Circuit, had just become a member of the Ninth Circuit, and because he was starting out, he didn't have enough to do, and he was reading the opinions of the other judges on the Ninth Circuit, and he came across the panel decisions in these cases. And he spotted the argument that was always lurking under the surface, but never really developed. And that was a First Amendment argument of whether or not Congress could appropriate private rights to a private organization in a word that had been in extensive use as the term Olympic had been for many years. He wrote a dissent from the denial of the petition for rehearing in banc. It was, in essence, a cert petition to the Supreme Court of the United States, and it's obviously what caught the attention of the United States Supreme Court. The Supreme Court granted certiorari, and lo and behold, the case went to Washington. One of the great disappointments of my law practice was that I was not engaged to defend the appeal in the Supreme Court. The client decided, and I'll have to admit from the perspective and the present and the fullness of time, I think wisely, that they needed somebody who'd been to the Supreme Court before, and I had never been there. So they hired John Kester of the Williams and Connolly firm to defend the matter on appeal, and he succeeded. But at the Supreme Court, things were different from below, largely because of the way that Kaczynski had teased out the underlying issue. It's true that once the case got to the Supreme Court, the discrimination argument had some resonance. It picked up 2 votes, Justices Brennan and Marshall, and Blackmun and O'Connor took the position that this is an issue that should have been developed in the district court. But clearly it was that First Amendment issue, not the discrimination issue, that drove the case to the Supreme Court and which made it a close case. I tell that story because of the tendency that we all have to look at things and to look at the law from the point of view of our own personal perspective. We tend to see the law in terms that suit our predispositions, our philosophies, our worldview. And one looks for an overarching theory which makes sense of the law that, after all, governs a complex of human relationships. I believe it is that which drove the defendant's attorney in the Gay Olympics case to emphasize the discrimination angle. And it comes against a background of the vast and growing body of the sources from which we derive the law. And in the past century or so, technology has increasingly driven this production. The widespread dissemination of case reports through increasingly sophisticated printing and information technology made common law available to judges and practitioners ever more readily, beginning sometime in the mid-19th century. By the beginning of the last century, that of course led to the formation, development of the American Law Institute and its publication of restatements of the law, which now cover virtually every field from agency to unfair competition. And this, of course, was an effort to keep up with the burgeoning body of common law. The restatements sought to make sense of this body of law and to a degree have done so and have come to guide judicial decision-making, even though the restatements are not themselves law. And legislative output has grown enormously in the last century at both the state and federal levels. This legislative output is driven, of course, largely by special interests that are affected by particular laws and by evanescent political considerations and concerns. Legislatively enacted laws are enacted one at a time, frequently in response to a single event or circumstance, often heedless of other events and circumstances, or enacted to promulgate a particular policy without regard to other countervailing policies. And, as you know, in some states we have this process magnified through the initiative process, and it's left to judges to sort out the inevitable conflicts and scholars to analyze and comment on the product of this process. So it is little wonder that scholars, judges, and lawyers have tried to make sense of all of this, to find the theory that makes coherent what at first seems so disparate and random. As I began my days of law practice in the antitrust field, and still labor to some degree in that vineyard, I often turn to that area when thinking about the legal process, and it affords an excellent example of an outstanding scholar looking for a theory to explain what seems incoherent. The scholar is Robert Bork, and the law is the jurisprudence that grew in the first 70 years of the Sherman Act. For its first 70 years of the Sherman Act, its intent and purpose were at best obscure. The Sherman Act is phrased in generalities, as sweeping as any found in the Constitution. Section 1 of the Sherman Act condemns as illegal every contract, combination in the form of a trust or otherwise, or conspiracy in restraint of trade or commerce among the several states or with foreign nations, and every person who engages in such conduct shall be deemed guilty of a felony. Section 2 of the Sherman Act makes it a felony to monopolize or attempt to monopolize or combine or conspire with any other person or persons to monopolize any part of the trade or commerce among the several states or with foreign nations. As the literal language of Section 1 is broad enough to embrace every conceivable contract or combination, its reach has long been limited to so-called unreasonable restraints of trade. And similarly, because every property right allows its owner the exclusive use of its subject matter and thus monopolizes to some degree, Section 2 has been held to condemn only unlawfully acquired monopolies or abuse of monopoly power. Because of the antitrust statute's generality, the courts have had to decide when the restraint or combination involved crosses the line from reasonable and thus legal into the realm of unreasonableness and illegality. And the courts have had to decide when a monopoly was acquired unlawfully rather than through skill, capital investment, or innovation. And even if lawfully acquired was in some fashion abused. The words of the Sherman Act do not make any of this clear or simple. So it's not surprising that the path of judicial decisions interpreting the broad mandates of the Sherman Act has been neither straightforward nor entirely rational. Indeed, until about 40 years ago, antitrust law was a jumble of vague, contradictory, and illogical concepts derived from the interpretations of the Supreme Court of the United States and the lower courts. Much of that jurisprudence sought to foster anti-competitive social and political goals rather than economic goals. And these included protecting small businesses from their larger and more efficient rivals. In the years shortly following the enactment of the Sherman Act, the Supreme Court of the United States said that that act's statutory purpose was not for real prosperity, but to protect independent businessmen, the head of his establishment, small though it may be, and prevent him from becoming a mere servant or agent of a corporation with no voice in shaping its policy and bound to obey orders issued by others. No less a judicial giant than learned Hand in the 1940s characterized the goals of antitrust as minimizing the helplessness of the individual and ensuring an organization of industry into small units for its own sake and in spite of possible cost. In another case in the 1940s, Fashion Originators Guild of America versus the Federal Trade Commission, the Supreme Court stated that among the policies underlying the Sherman Act was protection of freedom of action of members of the Guild not to reveal to the Guild intimate details of their individual affairs. In this interpretation, the Sherman Act had become something of a privacy protection statute. As late as 1962, the United States Supreme Court stated that the antitrust laws sought to promote competition through the promotion of small, locally owned businesses, even at the expense of occasional higher costs and prices that might result from the maintenance of fragmented industries and markets. But starting about 40 years ago, this situation began to change. It was a change whose origins lay in the academy, with the work of Philip Arita at Harvard, Ward Bowman at Yale, Richard Posner at Chicago, William Baxter at Stanford, Armin Alchian and William Dentzetz at UCLA, and many others. The work of these scholars found their way into briefs and arguments in the Supreme Court and in the lower courts. These scholarly endeavors contributed to a reworking of antitrust doctrine that aligned it with modern economic understanding. This made plain that the welfare of consumers should be the sole rational purpose and goal of regulating competition. Judge Bork, then Professor Bork, was one of these scholars, and his contributions to this movement in the law were of enormous importance and value. What is significant for our discussion today is that Judge Bork's policy insights preceded his discovery that the legislative history of the Sherman Act supported his preferred policy outcomes. In 1965, Judge Bork wrote a groundbreaking scholarly article advocating consumer welfare as the sole legitimate purpose of the antitrust laws. 1 year later, Judge Bork penned an article claiming that in the meantime, he had discovered that this too was the purpose of the drafters of the Sherman Act. Judge Bork's policy insight, I suggest, drove his reading of the statute's history, and not the other way around. And Judge Bork has not been alone in seeing his own policy outlook in his view of legal theory. Judge Posner, who I had at Stanford, did you have him at Chicago? A wonderful teacher and a fabulous, a giant of jurisprudence without any question. Judge Posner, when he was a professor, developed a theory that common law judges viewed cases with maximizing social welfare foremost in mind. Common law profit maximizers, as it were. I'm not sure to what degree Judge Posner continues to adhere to that view. His views have evolved in a lot of areas, but he, like Judge Bork in the antitrust area, looked for and wrote that he had found a theory to explain a vast body of apparently conflicting law. And Ed Meese, again, has put forward a normative explanation or guide to judicial decision-making. A judge or justice should interpret the Constitution according to its text, structure, and history. A judge or justice should set aside his own vision of the good society. This notion, of course, has sometimes been referred to as textualism. It holds that a constitutional or legislative provision should be interpreted literally as written. As a working principle, this approach generally is pretty unhelpful, as all judicial decisions based on the Constitution or a statutory text start with the text. And the Constitution, of course, is phrased in sweeping generalities such as due process, equal protection, cruel and unusual, and the like, concepts that hardly provide specific guidance in a particular set of facts. And statutes are very frequently contradictory and muddled. General Meese has told us that judges and justices should decide cases according to the law's text, structure, and history. And it's true, but it's incomplete. What the text, structure, and history of law tells us vary according to who is reading it. And during the 20th century, the law has become more rather than less fluid. Text has its limitations as a guide to judicial decision-making. But literal text reading provides to General Meese and those who subscribe to his view a standard by which judicial decisions should be measured. Some have advocated a somewhat different normative standard of constitutional adjudication, the original intention point of view. Justice Scalia has given this a somewhat different spin by focusing on what he says is not so much the intention of the founders as the public understanding of the terms of the Constitution at the time of its ratification. This apparently reconciles Justice Scalia's views on legislative history, which he says should be disregarded, with his view of constitutional interpretation. But it's based in any event on something of a conceit that a judge or justice in the 21st century can divine the appropriate public meaning of terms in the Constitution as publicly understood in the original 13 colonies. Now, some of this rhetoric to original intent and historicism is just that, legal rhetoric. Rhetoric, after all, is one of the skills that lawyers learn in law school. Close reading and argument are two of the others. In Justice Scalia's case, of course, associating your ideas with the founders never fails to lend heft to your position. And Scalia is hardly alone in his resort to the documents and understanding of our founding. And in the case of Scalia, General Meese, and Judge Bork in particular, there is a serious and a laudable purpose in their theorizing about proper judicial decision-making. They are seeking to define and thereby to limit the scope of judicial decision-making, lest it become essentially arbitrary and reflect merely the political, philosophical, or worldview of judges and justices. After all, a regime where important issues are decided by the policy preferences of unelected judges is hardly preferable to any other form of unrestrained authority. And federal judges are unelected, although, as I discovered, their selection is hardly free of political influence. But I think it evident that the advocates of textualism, historicism, and judges as economic maximizers figure out their policy preferences and then discover that the framers of the constitutional provision, the statutory provision at issue, or the common law rule just happen to have had the same insight. Judges Bork and Posner and Justice Scalia and others can be forgiven their use of these theoretical constructs. They are seeking to make sense out of the huge mass of decisions, statutory law, and legal principles, and then explain their positions in persuasive and credible ways. It is, after all, what judges and lawyers do. And judges and justices often engage in what would seem to the more casual observer to be rather arcane distinctions. One example of this, and of possible interest to the present audience, is the shift of Justice O'Connor's position from Bowers versus Hardwick to Lawrence versus Texas. In 1986, Justice O'Connor voted with the majority in Bowers versus Hardwick to reverse a Court of Appeals decision declaring a sodomy statute as violating the Due Process Clause of the Fifth Amendment. 17 years later, Justice O'Connor joined the majority in Lawrence versus Texas, declaring that the sodomy statute in that case was unconstitutional. Justice O'Connor sought to reconcile these two seemingly inconsistent positions by pointing out that her decision in Lawrence was based on the Equal Protection Clause of the 14th Amendment, while the majority in Bowers had held that sodomy was not protected by the substantive Due Process Clause of the Fifth Amendment. Well, one may put aside attempts at judicial psychoanalysis and accept Justice O'Connor's constitutional distinction on its face, while also noting that much had changed from 1986 to 2003 about the public's perception and understanding of homosexual conduct, and possibly Justice O'Connor's understanding as well. There is, after all, a sign of dry wit in Justice O'Connor's concurrence. She noted that although the sodomy statute in Lawrence had seldom been enforced, a conviction under that statute still carried the possibility of disqualifying one from acquiring a Texas license to practice various occupations. And Justice O'Connor noted 3: medicine, athletic training, and interior decoration. Well, wit frequently accompanies a measure of self-appraisal. Now, you may be tempted to chalk all of this up to something called the games judges play. But doing so would, I suggest to you, take you from healthy skepticism to a sort of a sad cynicism. In fact, there is a substantial rationality in the way the judges and justices go about their tasks, and that process is essential to an ordered and fair society. There are strong elements that guide and restrain judicial decision-making that inherently prevent its abuse, and yet allow its evolution and adaptation in a society and world that never ceases to change. The first of these is the intellectual rigor of the legal process and its inherent discipline. No one who's ever been to law school is unaccustomed to having his or her ideas and views go unchallenged, sometimes in a pretty hard-hitting fashion. Well, now this, of course, hardly eliminates all foolish notions in judges' decisions, but compared to the interest-driven and overheated windstorms of political campaigns and legislative hearings, affords a focus which tends to let the air out of a lot of otherwise unsupportable propositions and tends toward the arc of common sense. And given the very substantial discretion that judges are accorded, what is remarkable about the judicial process, particularly at its highest level, where discretion is the widest, is not the inconsistency of judicial decision-making, but its consistency. Take the Supreme Court of the United States. The Supreme Court is a court of essentially wholly discretionary jurisdiction. 98% of its cases come on what are called petitions for certiorari, which the court does not have to grant. In the course of a year, the Supreme Court receives about 8,000 such petitions. Of these, it grants petitions in only about 100 or so of these 8,000. A certain number of these are never decided by the Supreme Court for a variety of reasons. The petitions are dismissed because the court finds that the petition for certiorari was, as the court puts it, improvidently granted. In the course of the year, one wonders about an institution that seems to have so much improvidence about it, but in any event, in the course of a year, the Supreme Court decides and writes full opinions in only about 75 to 90 cases, less than 1% of the number of cases that it's called upon to decide. Because it hears only cases in which there are conflicts among the lower courts or in which there are novel but unsettled and important questions, one would think that the cases decided by the Supreme Court would be cases in which the interpretation of the law is the most problematic and therefore as to which reasonable minds could differ most often and most divergently. And yet, of the 80 cases decided last term by the Supreme Court with a full written opinion, 38 or 48% were decided unanimously. And 22 of them were decided by only one or with only one or two dissenting votes. That means over 3/4 of these cases were decided with very little disagreement. And the high degree of unanimity in 2010 was no exception, but has been consistent with the court's historical performance. Moreover, this convergence is reflected in the votes of the justices that are popularly perceived to be at opposite poles of the political and philosophical spectrum. Samuel Alito and Sonia Sotomayor were in agreement in full, in part, or in judgment 72% of the time. Ruth Bader Ginsburg and Antonin Scalia in agreement 65% of the time. And this level of agreement has been true throughout the history of the court. This could not happen without a broad consensus on fundamental professional, constitutional, and ethical principles. And part of this unanimity, of course, is the result of the text, structure, and history of the law, as General Meese and Justice Scalia have suggested. But it is also a product of a shared understanding among judges and lawyers of the role of law in the judiciary in a free society. And this understanding is the product of that discipline and intellectual rigor of the legal profession. Justice Scalia made this pretty plain in his dissent in the Lawrence case when he railed against what he called a law profession culture that is largely signed on to a social agenda that he found unacceptable. Well, and there's something else that shapes these decisions in ways not fully appreciated with the media's and politicians' focus on the personality and philosophies of judges and justices. When I started practicing law and was confronted with a problem that seemed utterly pedestrian and common, I figured there must be a host of cases that had addressed the factual situation at hand. I was continually surprised at how often there was nothing on point. Yes, one could find a case or cases that involve somewhat similar facts, or a statute dealing in some fashion with the matter at hand, but there would always be some distinguishing fact or circumstance, so the authority did not quite fit. So one had to draw analogies or parallels, and in so doing there would be room for maneuver or argument that there was a better or more suitable way to address the problem. We have what often seems an overwhelming mass of law, but the gaps or interstices are more frequent and wider than most perceive. Our political dialogue fails to acknowledge this indefiniteness of law. When a judge decides a case in which there's this kind of wiggle room, the judge is making law for that case, and that decision may afford authority in a later case for a situation that similarly bears a resemblance to the case, but probably is not quite on point. This has been called discovering or pronouncing the law, but it's judicial law-giving at bottom. And there's another way in which judges exercise discretion to make and change law and do so fully consistent with our constitutional structure, and yet, in the process, are restrained in doing so. Society and the economy and our political institutions are not static. Attitudes and learning are dynamic, they're ever changing. I mentioned this in connection with the antitrust laws, and it is evident as well in the slow disintegration of the separate but equal doctrine of the Supreme Court's Plessy decision in 1896. What the Supreme Court's 1954 decision in Brown did was not so much change the law as reflect an understanding of the role that a person's race played in our society. Plessy was decided only 33 years after the Emancipation Proclamation. Plessy came at a time when most African Americans lived in virtual servility, if not de jure servility. The aspirations of the 13th, 14th, and 15th Amendments could be and were understood by men of that era to be satisfied by separate accommodation for the races. In hindsight, this seems exceedingly short-sighted, but it would be a mistake to ascribe this view entirely to ill will towards African Americans. It should probably be seen as simply reflecting a viewpoint cabined by the times in which these justices lived. But the 20th century, and especially the movement of African Americans in large numbers to the urban centers of the East and the Middle West, their increasing prominence in popular culture and sports, the need for their labor in arms, in wartime and in factories in peacetime, their successful integration into the military and into that most American of sport, Major League Baseball, in the late 1940s, shaped the Supreme Court's understanding. And the understanding was not so much of law, but about people and institutions. It is this kind of understanding that in some cases calls upon judges to be lawmakers, to reject or correct laws based on a different and plainly discredited understanding. But it is not alone the wisdom of judges that drives this change. It is the legal process itself. And courts are particularly well suited in some situations for making law even on fundamental issues. After all, unlike elected officials, judges, particularly federal judges, are not looking to the next election for vindication or retention of their positions. A courtroom is hardly a laboratory suitable for scientific experimentation, but factual premises that underlie many social, economic, and political policies that have been legislatively enacted are exposed in a courtroom in a way that is not possible elsewhere. In the hurly-burly of electoral politics and the halls and hearing rooms of legislative bodies, long-winded and evasive assertions are rarely challenged effectively. But a courtroom is different. One prominent litigator has said, the witness stand is a lonely place. It is especially lonely for someone who spouts a racial or gender theory, propositions without credible support, or dogmas born of myths and unsubstantiated beliefs. Yet each of these has been and continues in the present day to be the support for so-called legislative findings or facts that have been enacted into law and that treat some citizens differently and without reason. In a courtroom, these findings or facts can be exposed for what they are: propositions born of misunderstanding, bigotry, or intolerance. And that is precisely what happened in the Brown case. Contrary to much of what has been said about that case, it was not the product of the Supreme Court acting on its own initiative. It was not solely the product of Chief Justice Warren's political skills in marshaling his colleagues to render a unanimous decision, and it certainly was not the failure of advocacy on the losing side, as the lawyer who argued for the losing side was the preeminent Supreme Court advocate of his day. And Brown was not one case, although it has acquired one name. It was one of 5 cases that had come up through the lower federal courts on a record that included the testimony of witnesses who described the profound disparities in the educational facilities and resources provided to African American and white children in their communities. The trials featured expert testimony of renowned scholars about the stigmatizing effects of racial segregation. And it featured the riveting cross-examination of Thurgood Marshall, of the defendant's star witness, which exposed that his testimony was based simply on an untested and unsubstantiated belief about the superiority of white citizens. And there is another restraint on judges when they adjust law to fit new facts or the understanding of those facts. a restraint more effective than literalism, historicism, or economic theorizing about judicial decision-making. A judge's error is more easily corrected than the errors of a legislative body, or the populace through the initiative process, or the executive's promulgation of administrative rules and regulations. And judges do err, of course. But there are courts of appeals, and in our system, the Supreme Court. And even the Supreme Court is not free from error, as Justice Jackson noted when he said of that court, "We are not final because we are infallible. We are infallible because we are final." Well, that is what judges do and what they must do. Unlike politicians, judges must decide the matters that come before them. In so doing, they do not merely look at their own policy preferences or views of the world, but they are frequently without clear, apparent, and fixed legal standards, because those standards simply do not exist. Case by case, what judges do and must do is take account of the facts, obtain some guidance, such guidance as the lawyers and the law affords, and decide the case in a context that is sometimes larger than the situation at hand. If it seems that the process is indefinite and without rigor and consistency, this would be wrong. But if it seems that the law is clear, definite, and a certain lodestar, then that is equally wrong. What lawyers, observers, and even judges themselves sometimes fail to appreciate is this essentially pragmatic character of judicial decision-making. It is hard to explain and sometimes hard to divine, but it is real. That is why sometimes lawyers focus their case on points that fail to succeed, or pursue arguments that have little or no chance of success, or miss or neglect an argument that holds greater promise, as perhaps did my adversary in the Gay Olympics case. This is a particular danger for lawyers and parties who litigate a case as a cause rather than simply a dispute to be resolved. They tend to see the law, they tend to see the facts in terms that are too narrow, too focused. And judges and commentators who would explain the legal process with some unified and comprehensive theory or construct like strict construction, textualism, or welfare maximization will always leave too many decisions and too many outcomes unexplained. Judicial decision-making entails not application of a philosophy, a theory, or outlook. Rather, it is a process that at bottom is pragmatic and ever-changing. And that is why every judicial decision goes only to the case at hand and offers at best tentative guidance for the next case, and sometimes no guidance at all. Law is not text. Law is a journey. For me, it has been, and for those of you who join in this endeavor, I trust it will be, a grand excursion. Thank you.
Our tradition at a great law school like Indiana is that when interesting and challenging and ideas born of experience are put on the table, we like to not only hear them and receive them and think about them, but to discuss them as well. And so for that part of our program, I'm delighted to welcome two faculty members from Indiana University who have great interest in the kinds of issues and controversies and cases that Judge Walker has talked about. Charlie J. teaches here at the Maurer School of Law. His specialties in teaching and research are in judicial independence, accountability, conduct, and ethics. And Judy Fahler teaches in the IU Department of Political Science. Her interests are broadly in legal and constitutional theory. She teaches constitutional law and also specializes in the justification of rights. We invited them because we thought they would have some very interesting comments and perspectives on Judge Walker's remarks, and after they've had a chance to give their thoughts for a few minutes, we would welcome your questions and contributions to the dialogue as well. So, Charlie.
I'm just going to take, I think both of us are going to take about 5 minutes, and then sort of have a discussion. But as you can tell, Judge Walker did not talk about the Proposition 8 case. He did not talk about being a gay man and judge deciding the Proposition 8 case. That is the elephant in the parlor of his condominium trying on his clothes. And I want to spend a moment talking a little bit about why he didn't do that, and then connect up essentially the themes that he is striking with the Proposition 8 case in a way that I think will hopefully link the two together. I think that although he explained that he would not be talking about it, the reality of it is that Canon 3A6 of the Code of Conduct for United States Judges says, a judge should not make comment on the merits of a matter pending or impending in any court. Now, from the standpoint of the audience, this, I think you might fairly look at this and say, what the hell? That you would learn a great deal from Judge Walker's thoughts about this over and above what he has in the opinion, that I think you'd walk away even more confident in the administration of justice knowing that. And I think you can go further still and say, as a technical matter, he's no longer a judge, so what's with this code provision applying? But the reality of it is there's someone else to worry about here, and that's the parties. That if you are the parties in this case, I'm not sure how you'd react to a judge turning cheerleader, going out as a lobbyist for his cause, and looking like an opportunist, in a post-judicial career, going stump to stump. And I think for that reason, what Judge Walker's done here is taken the high road, and he's to be applauded for it. That doesn't keep me from talking about it, though. And I think that in some ways I was fascinated by the irony that Judge Walker began with, because what he's basically saying is, in the United States Senate, everybody says they're all about the rule of law, and they are going after judges who are opposed to the rule of law, but it's essentially a rather craven point of view, which is our view of the rule of law is whoever supports our side. And that's the shallow, politicized view of the rule of law. When you get out there and you're a judge, and you have to decide cases, and people either lionize you or hate you, and it's all about the rule of law. This judge either follows the rule of law or disregards it, and it's all about whether you happen to have a decision that they favor or not. Now, I think that ultimately, at the end of the day, what Judge Walker is saying is there's more there than that. That really, and I think, from my way of thinking, the reason Judge Walker is, in my mind, an heroic figure is not because he upheld gay marriage. It's because he wrote an opinion that more than one commentator who looks at it closely says is airtight. In other words, he has written an opinion that tracks the law in a way it's not a public policy statement. It is an opinion of law, and it achieves the objectives that I think he is seeking to achieve. Now, does that mean that this business of a gay man deciding a decision like this is utterly irrelevant? In other words, that sexual orientation is irrelevant to the decisions that judges make. And I think that the answer there is, yes, it's irrelevant. No, it's not irrelevant. Yes, it's irrelevant, and no, it's not. I'm not a judge. I'm a law professor. I get to waffle. At one basic level, and this connects with General Meese. I'm never really quite sure exactly. I sort of see him in a pointy hat. With General Meese saying it's all about the rule of law and strict constructionism, and if it's all about the law, we don't care if the judge is black, white, man, woman, puce, gay, straight. The law is the law by God. It's irrelevant whether the decision, the orientation of the decision maker. And so to that, it's irrelevant. On the flip side, we know better than that. We know better than that in the sense that the law isn't clear. Judges exercise discretion, and their experience informs that discretion. And to say that who they are is irrelevant to the way they look at the world and the law, I think is overly simplistic. And Judge Walker emphasized the 60% of the time when justices agreed, that still leaves 40% when they disagree. And when they are figuring law out at these margins, they are thinking it out with reference to who they are. And who they are can be a matter of their ideologies. And we have studies showing that ideologies matter. Their race and their gender, and we have recent studies showing that in certain kinds of cases, that matters too. And the idea that Judge Walker's views of the world are utterly uninformed by his status in it as a gay man strike me as a little foolish to contemplate, any more than mine as a heterosexual man are. And so to that extent, does sexual orientation matter? It can, sure. So it does. But in a deeper way, what does that mean? That we can say that, some have been led to wonder because of just that statement. Some rushed out and said, hold on, this is a gay man in a stable relationship. How can he be trusted to uphold the law in the Proposition 8 case? And I'm reminded in some ways that, that view strikes me as operating on the same conceit that you sometimes get in conversations where people say, does that person speak with an accent? I mean, do they have an accent? What that really means is, do they speak the way we do? In other words, everybody has an accent. It's just that they speak the way we do. And so when we're talking about whether a gay person or a black person can decide a gay rights case or a race discrimination case, what we're saying is the neutral person is the straight person. The neutral person is the white person. They have no perspective, right? And that's foolish. But if you agree that's foolish, if you agree that everyone is informed by the experiences of who they are, then the moment you start disqualifying people because of that, everybody gets disqualified and we all go home. And so to that extent, his status is utterly irrelevant, because if we make it relevant, everybody goes. All right? Final point is that it's ultimately relevant still, because one can say that everybody speaks with an accent and still say some people speak in an accent that's too thick to understand. Right? In other words, we get the white supremacist out there, well, it's just a perspective. No! You can't function. You're an anarchist. I'm sorry, you can't function. That in that way, the Senate does perform a useful purpose. And when Justice Sotomayor was heard to say, as a Latina woman, I would decide things differently, I think the inquiry is worth saying, how differently would you decide it? Are you simply saying it's a matter of perspective, or are you saying that I am so committed to my race and gender that I'm going to basically say, law be damned, I'm going to do what I'm going to do? I think the short answer, it was the former. And the process reached the right conclusion. But you can anticipate the possibility that, it would go otherwise. Flip side of it, too, is that in a world where experiences improve judging, the more experiences, the better. And so to be totally tone deaf to who the judges are seems to deprive us of the wealth of experience that comes with having black judges, white judges, male judges, female judges, straight judges, and gay judges. And so to that extent, it does matter a lot. And having waffled my way, through my 5 or 7 minutes, I am now going to shut up and turn it over to Judy.
Do you want to respond to that first, or?
Oh, do I respond
I don't
once
know.
at a time?
Do you want to? If you want to.
Well, I was amused by your reference to an accent. I just got back from Cuba. And I said to my partner, after we were listening to this woman, I think my Spanish is getting better. I think I understood about every 5th word that she said. He said, she's speaking English. So she did indeed have an accent. It was incomprehensible. You're right. I'll call you Charlie, if that's all right. Of course, people's experiences matter. That's a point that I was attempting to make in connection with the Plessy case. Those justices were not necessarily evil people, but they were cabined by their life's experiences, by the times in which they lived, and that, I think, explains what we now regard as a gravely unjust result in that case. So, for good or ill, judges and justices are inevitably affected by who they are and what they are. But at the bottom, if we start picking judges on that basis, we won't have any judges.
Okay, I wanted to focus, if I could, on your observation that you made toward the end, that judges don't just make up the law, and neither do judges follow the law strictly. That the reality is that the law is something in between and that it's a function of a process. I think that's right. And I would like to just underscore some of the ways in which legal theory agrees with you, and then pose some questions that come up from that perspective, from a jurisprudential perspective. On the one hand, the approach of understanding law as just a set of rules, and if the comes from positivism. H.L.A. Hart articulated it most famously, and he says that it's the combination of primary and secondary rules, and if a judge needs to decide a case where there are no rules, the open texture of the law, he would say, then it's completely up to the judge's discretion. And he just makes it up. Now, for us, this seems completely offensive and uncomfortable, because what is he going to do? He's going to make it up with his personal values, and he's going to make it up with his agenda, or he's going to make it up with whatever it is that he is going. So that makes us all very uncomfortable. On the other hand, at the other end of the spectrum, is an approach by Ronald Dworkin, who responded to Hart on his legal theory and what law is, and he came up with the idea that there is one right answer in law, because the law is a complicated web of ideas that include our beliefs and our practices and the precedents that have gone before, what people think on higher courts, what people are thinking on in lateral courts. He wants some kind of integrity to the law, and that's going to have to be explained in part by our, I guess it would be our best political theory, is the way he would put it. Our best political theory that explains the whole legal process, our best constitutional theory, our best understanding of what the Constitution is all about. And I very much appreciated how you articulated how our understanding had changed over time of what the Constitution actually meant. What he ends up with, Dworkin ends up with in the end, though, is that there may be one right answer, but we lack the ability to necessarily know what it is epistemologically. So it may make us feel better to say that the judge is deciding what the law is and identifying that one correct answer, but as an epistemological matter, we don't really know that right answer when we see it, and so we're left with the problem that the judge might very well be making it up and isn't receiving sufficient guidance. So either way, you're right. You don't want the law to be too much where the judge is just making it up. You don't want to assume that it's predetermined, because how would we ever be able to work that out and know that and agree on what that would be? So yes, I agree with you that law is somewhere in the middle. But I would also want to suggest that even though we're somewhere in the middle, in your talk I might have misunderstood. It seemed that there was some of the judge's wisdom and understanding about the cases that led them to make better decisions, different decisions. So O'Connor's understanding of equal protection to due process, but sodomy laws changed over time because there was a kind of a sea change in our community, and she was supported by that. The transition on equal protection between Plessy and Brown, also we see a kind of transition and a growing wisdom in that. And I think that's great, and I think that's right. But it does run counter to the idea that sometimes judges need to step in and do what you did, and we're not allowed to talk about this, but what you did when you see a majority and trying to pass a law that is discriminatory. When you have discrete and insular minorities, to use the language of Stone's footnote 4 in Caroline Products, who can't protect themselves through the ballot box, we need judges to stand up for people who aren't the majority, who are not part of that sea change of wisdom. And I believe there are times when judicial wisdom may run ahead of popular opinion. So I'm not sure how we justify that in the end. Of course, we know that you did and did a great job, but it is something that worries me. If judges are supposed to be appealing to the social milieu and kind of where we are in terms of our morality as a society, don't they run the risk of just reinforcing the discrimination that the majority is putting into place? That's my worry.
What you have to remember is judges don't act as self-starters. They don't bring the cases. Somebody brings the case. Somebody has a claim or a defense that has to be adjudicated. And the point that I perhaps didn't emphasize strongly enough is that it is the fact-finding process, the legal process itself, more really than the wisdom of judges, that contributes to moving things along and moving away from outmoded notions and outmoded legal constructs. There is nothing like a trial to expose all kinds of things. And if we have a deficiency in our present system of justice at the present time, is we have made it so expensive for trials that we don't have enough exemplars in a whole range of areas, not just these kinds of broad social questions and constitutional issues, but in much more pedestrian areas. Trials have a way of bringing out things that really don't come out anyplace else. And they contribute really more than the wisdom of judges to bringing forth the facts that can move the law. So don't overlook the process itself and what a contribution it makes to righting the ship of state when it gets a little off kilter.
Yeah. Just one quick follow-up. I was thinking about Justice Ginsburg's concerns that she articulated before she was a justice when she was advocating on behalf of women's rights, and her lamenting that Roe versus Wade had moved the ball forward for abortion before the state legislators around the country had been ready to do it. And she was speculating maybe it would have been better had we allowed the states to kind of catch up. Because even though it's true that you can bring in findings of facts and evidence and learn, and the judge can make the right call, perhaps, hopefully make the right call. We don't know if it's the right call, but we're not God. But at any rate, presumably it's going to make the right call. But if the rest of the community isn't ready to catch up, so abortion is a mess, in part because the judicial process went faster than the legislative process.
Perhaps it did. Bear in mind, abortion is really a very troublesome area, both ethically and legally. At bottom, it's morally ambiguous. At some point or other, this, whatever you call it, is going to develop into a human being. And at some point or other, society has a right and an interest in protecting that as it becomes a human being. At what point is really the issue. So it's different from some of these other areas. I think it's different from the separate but equal doctrine that Plessy imposed. Inherent in abortion and in abortion jurisprudence is the ambiguity, the utter ambiguity of the ethical situation. And you don't have that same degree of ambiguity in some of these other areas.
Okay. Let's take some questions. Those of you who have heard things that you're intrigued by or want to know more about, now's the time. Yes, Don.
Judge, to the best of my knowledge, the issue in the Pompey case, and I don't believe it, of whether or not the plaintiffs have the ability and standing to bring an appeal of your decision, not to bring it to you.
There's no question they had a right to intervene.
Right. But as far as the question that is, my understanding is before the California Supreme Court, any news, any insight with respect to that? Do you care to comment on that, or do you feel like you can?
I don't know what the California Supreme Court's going to do. I mentioned earlier this afternoon when somebody alluded to that subject that I thought they were going to try to find a way to afford some form of standing to the proponents so that the case could go on, but they didn't want to open the floodgates for every initiative proponent to come in and defend initiatives. And they're concerned about this, I'm sure, from a state law perspective, and properly so. I will tell you an anecdote from the Proposition 8 case. not discussing the case, as you know, but I think I can tell an anecdote, so if you'll give me a chance. As you know, one of the lawyers for the plaintiffs was David Boyce, who was an exceedingly able lawyer. Well, many years ago, long before the Prop 8 case was around, before Proposition 8 was in anybody's contemplation, we had invited him to come out to a Northern District of California conference. And I was chief judge at the time, and we were sitting just like this, getting acquainted. I'd never met him before, and he'd never met me. He talked about his children. And I asked, what are the ages of these children? And he gave some very wide range. I can't remember the details, but it was something like 14 and 42 or something. It was a huge, huge range. And I said, well, gee, that sounds like 2 marriages. 3, he said. So in the course of the trial, he was examining the proponent's political science expert, who was going through polling data to identify groups in society that were highly regarded and those that were not highly regarded. And he started at the top and he moved down, step by step by step. He came to second to the bottom, and they were gays and lesbians. And then he asked the witness, now what group, Professor, in society is regarded less well than gays and lesbians? To which the answer was, people who've been married 3 or more times. And the look on David's face when that answer came out was priceless. I don't know if he remembered telling me the story or not, but I certainly remembered it at the time.
An example where the famous rule was violated, I guess, that a lawyer never asks a question which he doesn't already know the answer for. Other questions, please. Yes.
During your talk, you said that preceding cases can only inform us so much as to new facts and circumstances. So I was curious as to your thoughts on exactly how much discretion a judge should have in deciding how controlling precedent is, and just how much prior cases inform judicial decision-making.
Well, one comment I didn't make about Judy's observations, but it did strike me when she was making them. She almost suggested that there are some cases that come along where you don't have any rules. I've never seen a case without rules. I'll tell you, there are more rules than you can shake a stick at that you have to deal with. And they're frequently in conflict. They frequently have to be resolved. So in the situation that you pose, you very seldom have a case of any magnitude where you don't have some kind of a conflict among the authorities that are arguably applicable to the principle. Sure, there are some that are pretty straightforward. Some cases are kind of cookbook kind of cases. You just go and look at the statute or the prior decision, and that gives you the answer. There are those cases, but nobody talks about those very much. But usually where the case poses any difficulty at all, you are resolving conflicting authorities. And how much weight you attach to those authorities depends upon a host of factors. The currency of the case or the statute, whether it squarely fits the situation or you have to bend it to make it fit. It really is impossible to give an answer about how much weight you give to any arguably binding or applicable authority in a situation.
I wanted to embellish in some ways to cycle back to a point that Judge Walker made during his talk, that toward the end he described pragmatism as kind of the approach he takes to deciding cases, but what he just described is that. In other words, you've got law, you've got, it says something, but it doesn't resolve the matter. And at that point, you end up having to fill the interstices of the law with considerations of legal policy and what the implications are of that policy. That sort of plugs into what I was saying about, who the judge is, and being informed by experience helps them to make pragmatic choices at the margins where the law doesn't completely answer questions. And Posner has written a book about what judges do that I think is terrific, that really elaborates on the pragmatic method, if you want to call it, as you referred to.
Other questions? Yes, Dean Buxton.
Judge, I wanted to follow up on your point that the fact-finding process in litigation can be a really powerful tool for analyzing, examining the viability of some of the assumptions that underlie our social attitudes regarding some of these issues. And what I'm wondering is whether you see a second step in that process where the facts that come to light regarding those assumptions during litigation then translate out into social understanding as well. In other words, is that message carried only in the decision itself, or do you see a process by which what comes to light in that fact-finding eventually comes out of the courtrooms and out into society?
I think that occurs and can occur in some situations, which is one of the reasons that I'm an advocate for cameras in the courtroom. I think people ought to be able to see these cases and how they are litigated, how they are decided, what happens, and I think that would be very constructive in informing people's views. I think cameras in the Supreme Court would be extremely helpful. People would see that even decisions that they disagree with, there are arguments on the side of whatever that decision is, and would understand that these issues are not cut and dried, they're not simple, and that there is a point of view other than the point of view that you happen to hold. So I think there is that feedback. But one of the problems is there isn't enough accessibility that people have to the legal process to watch it unfold. And I think that's highly unfortunate, and that inhibits the kind of osmosis that I think you're referring to. Reverse osmosis, I guess it would be. And just another observation in connection with that. My adversary in the Gay Olympics case, I think I talked about that enough to set the stage, had neglected an opportunity to develop a factual record with respect to whether the action of the Olympic Committee in enforcing its trademark rights under the Amateur Sports Act would constitute state action. Had she done that, that would have been the hook to hang the discrimination argument on. But she didn't do that. And well, you never want to criticize your opponents for failing to do what they should have done, but that's what you need to do in some of these cases, to build on a factual record. And a lot of lawyers who are adjudicating what I characterize as cause cases fail to understand the significance and the value of that factual record.
So another question here.
With regard to, we notice the difference between a textual approach in interpreting statutes as opposed to one that tries to tease out the intent or the purpose of the legislature in interpreting statutes. Would you say one approach over the other is more inherently gives more of the opportunity for a judge to instill his own substantive values into interpreting statute, or would you say that it's more it has more to do with the judge herself?
Well, let's see. Tell me again what the conflict is here.
A judge who proclaims to use a more of a textual approach, like schooling up, interpreting the text of statute to determine its application, as opposed to one who is guided more by what he or she perceives as its purpose and looking at the legislative history of it. Would you say one or more is inherently more likely for a judge to instill his own substantive values, or would you say that
after all, there are a lot of cases in which you feel that you're bound by the text and you can't depart from it. And even if you want to, and even if you think it's an unjust result that you're having to come up with. But there is, as has been described, no end of situations in which you have plenty of opportunities to rely either on the text or on some kind of historical understanding or some legislative history, and how much emphasis you place on one or the other will depend, it is true, on your view of the value of these sources of law, but it will also depend on what you think you should rely upon to achieve a just result in the case at hand.
You have been a very patient and an attentive and a good audience. We would like to invite you to continue the conversation somewhat more informally at a reception upstairs where we have some very good food and drink. It's on the 3rd floor in the faculty lounge. We will all be there, and so we invite you to come and join us as well. And finally, we have some parting gifts for Judge Walker. I think we know it gets cold in those Bay Area foggy evenings, and so there's an IU blanket and some other things in here as well. So,
great.
So
thank you very much.